Warning, we are not your attorneys. Please, don't take anything we say as legal advice. I'm Geoff.
I'm Mike.
And I'm Derrick.
And you are listening to the Not So Grand Jury,
which is still sponsored by More Law PLLC.
All right. So, good day, everybody.
Hello.
You got Derrick and Geoff here. Mike is sitting this one out. I don't think we did anything to him. He just can't make it today.
Yeah, he's got a life and stuff.
One of us does, at least, apparently. So, So we have, I'm not sure if fun one's the right word, but we have an interesting one today. We're talking about Always Sunny in Philadelphia, Season 8, Episode 10, called Reynolds versus Reynolds. What is it? The serial defense or whatever the hell it's called.
Yes.
This was recommended by my friend Paul, who has actually sent me about 6 other things to look at. This was the easy one to jump in. So thank you, Paul, for the recommendation. Very quick plot summary, but highly recommend you watch because it's only 20-something minutes and it's real stupid and it's hilarious. So it'll be a quick... No doubt our episode will be twice as long as the actual show, if I had to guess.
Probably, yeah.
Yes. All right. So brief summary. In this episode, Frank, who is played by Danny DeVito, crashes his car into Dennis, who is played by Glenn Howerton. To clarify, crashes his car into Dennis's car, who was eating cereal at a red light, like you do.
Like you do.
Frank and Dennis decide to stage a mock trial to determine who is at fault. Dee, played by Caitlin Olsen, initially acts as Dennis's lawyer. Charlie, played by Charlie Day, acts as Frank's lawyer. And then Mac, played by Rob McElhenney, he starts out playing as judge and bailiff and then starts playing about 9 other roles during the course of the quote-unquote trial.
Sure.
And I will just say weird stuff happens.
I've never seen this show before. And
okay.
I realize as someone who lives in Philadelphia, maybe that's sacrilege. I don't know. But this episode is called Reynolds versus Reynolds. Are Danny DeVito and Glenn Howerton's characters related?
Okay, so I had to look this up too.
Okay.
As I understand it, Danny DeVito he's not the actual father. He is the papered father of Glenn Howerton's character and Dee's character.
Okay.
And they are twins.
They're twins. Okay.
Again, in the show.
Adopted by Danny DeVito's character.
That is my understanding. Because I've watched a little bit of Always Sunny, but never really sat down to watch it. I have seen probably 20 episodes in completely random order. Couldn't tell you anything about any type of ongoing plot or any type of continuation. All I can tell you is I've watched random... Typically in a situation where someone's, you should watch this one. And I watch this one and I have no idea where it is in the continuum of nonsense.
I imagine it's not a plot-heavy show.
I would not think so. Yeah. I would be shocked if... I almost would think that every episode probably could stand on its own in a different way as long as you know that the characters are a little insane.
Okay.
That's my understanding.
I got that much from the memes.
And what's also funny is they all, in some capacity, work or own the pub they're in.
Okay.
So when they were doing the quote-unquote mock trial, the pub was open.
Sure.
As by the fact that there was a dude there.
Who thanks them at the end for entertainment? I don't know.
Unclear if there was any payment made. Unclear if he just made his own drinks. It was actually a little unclear, which I think just adds to the sort of hilariousness of the show. So first off, I think for the listener, this is the perfect episode to get back to basics because Lord knows there's not going to be a lot of complicated legal discussion for purposes of this one. Because if we did, I think we'd be missing the plot.
Yeah, this would just be one of those reaction videos where we just watch the thing and comment.
And it would just be, oh my God, the whole time, basically. So I think it makes sense to first jump into what would really happen in this situation.
Sure.
Which is actually, and I would be curious, Geoff, if you have any opinions, I think it's pretty straightforward. Frank rear ends Dennis. The car is not moving. He is stopped at a red light. Therefore, Frank is at fault. That is pretty straightforward. Now, and the part that actually is interesting on the legal stuff is how much of the damage was caused by Dennis. Here's the thing. To my knowledge, no law that says you can't be eating in your car.
True.
No law that says you can't be eating cereal in your car.
As far as I know. I've not done a deep research into that question.
I did a very super quick research and I could not identify anything.
Unless,
and by the way,
unless you were down to just the milk and were sipping it from the bowl, and maybe they hit you for drunk driving or drinking while driving or something.
What kind of milk are you drinking that would cause drunk driving? It's just a White Russian.
Right,
that's all
White Russian. Thank you.
Which, by the way, could have happened in Always Sunny. There's a very good chance that he's actually. It's a chance that it's cereal in the White Russian. Honestly, why wouldn't it be? So, in real life, and I say real life in the sense that let's assume this actually goes to some form of decision maker. Small claims, probably. Whatever
we don't know what the damage is. Presumably, it's like water damage from the milk. Maybe electronics, it seeped in and damaged some electronics under the dash.
I will say the milk goes everywhere.
Sure.
Like, it's actually impressive how much he flings the milk. Twice, in fact, at the start and at the end.
I have to wonder if they rigged the car on something where they could jolt it a bit.
I got to assume so, because it actually looks pretty realistic, I will say. What would very likely happen is that Frank would be found mostly liable. If not 100%, 95%. And maybe they would say there's a slight Dennis having a open bowl with cereal caused a little bit more of the damage, but it's Frank's fault. There's just no question.
Yeah. And I wonder, as I was watching it, there's the concept of the eggshell plaintiff, where if you commit a tort on someone and it so happens that in doing so, you inflict far more damage than you might have expected from an action like that. If I get in a bar fight and punch somebody in the face, and it turns out that they have a bone condition that means that completely shatters the orbits of both their eyes and causes an insane amount of medical damage from a punch in a bar fight, that's on me for throwing the punch. Like that. Derrick is holding up a torts textbook.
I actually went back to confirm that the case I actually remember from law school about the eggshell plaintiff, which was Vosburgh versus Putney from 1891.
That rings a bell.
Is in fact, I think that's the quintessential case that any lawyer who's listening may be having Vietnam-like flashbacks right now. That is the case that's typically taught about what is the concept of an eggshell plaintiff. For Geoff, you can go to page 2 of the outline. For anyone who's listening, don't worry about the outline because that's not what we're going to talk about. What Geoff says is 100% correct. So it's a general rule, and every jurisdiction can be different, but the general rule is that you effectively take the victim as he or her is. In other words, you take them as you find them. Defendant cannot escape liability just because there was an unusually fragile condition or a pre-existing medical condition or something that was unforeseen that would have caused additional injury. So the case that gets discussed in law school all the time, an 11-year-old boy playfully kicked a 14-year-old classmate on the shin below the knee. It wasn't on the playground, it was while they were in class. The kick was minor, but then the 14-year-old had a pre-existing bacterial infection in his bone that was unknown to the plaintiff. Kick aggravated the bacteria, causing the kid to lose the use of his leg and having multiple surgeries. And there was a whole bunch of litigation for over 4 years that happened over the situation. And the Wisconsin Supreme Court basically established the precedent that, what I just said, the wrongdoer is liable for all injuries resulting directly from the wrongful act, whether or not they were foreseen. In that case, there's a whole thing in that case where, effectively, the trial court basically said in their decision that the parents should have figured this out and that they're being idiots by not having figured it out, which is always fun when you look at a decision and they're like, parents were dumb, but here we are. And in the end, I know there was 3 different trials and the whole thing was kind of nonsense. And then the dad sued for his son's anguish. And then there was also a criminal, whole bunch of litigation that happened over this kick. But that's really what came out of it was the eggshell plaintiff rule. And that's kind of what we have here. It's not the eggshell plaintiff rule. It's the cereal eating plaintiff rule.
And I will say, if this same scenario happened now, there would almost certainly be litigation because there's health insurance involved. And they would want to, the insurance company would take steps to recover, to not have to pay out of pocket for the surgeries caused by the accident. This is why you wind up with a child suing an uncle for slipping and falling on their property because there's insurance involved and they are going to do what insurance companies are going to do.
I was going to say, sometimes you look at just the plaintiff and defendant and you're like, how did this happen? You want to know what? Sometimes they just send it to the insurance company who then hires insurance counsel. I do believe they have to get some sort of, they have to keep the plaintiff and the defendant in the loop. But if in the end, the insurance company wants to sue, they're going to sue. And that's just how it works. In fact, this is sometimes why we have insurance. You let the insurance companies figure it out for themselves in hopes that you don't have to be dealing with anything.
And actually, going back to one of the King of the Hill episodes we talked about, what's his name was self-insured. If he had been insured, Hank probably would have been sued anyway.
Yes, self-insured. Always a good decision.
He wasn't suing Hank. He was suing, who was he suing?
Was it, Dale?
Dale.
The guy who still confuses me what he actually does on the show, and apparently he's married to some known anchor or something on the news networks, but we still have not seen her. You and I still have not seen her in the 4-ish episodes we've watched. No, more than that. A whole season plus 4 episodes.
Yeah.
Oh, and Mike's not here to defend it. How sad.
That's what you get for having a life. We made the right decision.
Sam Adams, always a good decision. Yeah, so the eggshell plaintiff is definitely a rule, which I think adds to another reason as to why in real life Frank is completely on the hook. This also gives us the opportunity to talk briefly about the concept of comparative negligence, which we briefly discussed this on one of our, and I'm not going to remember which episode it was, where every jurisdiction has some different rules where if you are found negligent, like how negligent you are is going to determine if you can recover. So here, this is Pennsylvania, and yay, Geoff, you actually get to talk about Pennsylvania law as a Pennsylvania admitted attorney. That's weird and rare on our podcast. The Pennsylvania law, weirdly, I'm going to talk about it, but the Pennsylvania law is that an injured party can recover damages as long as their share of fault is 50% or less. So in other words, if you are more than 50% at fault for the issue, you cannot recover at all. And that typically happens in construction injuries where it could be like the fault of 4 different people. It is car accidents where one party's 5% whatever it is. So in other words, if a good example, you are found to be 20% at fault for an accident, the other party is 80%, you can recover 80% of your total damages. The 20% gets taken off because you are at fault. However, if it turns out that you were 60% at fault for it, you can't get the 40%. You are basically the other side cannot be found liable because you were the mostly at fault. Again, here, if we were to take this, assuming this went forward in Pennsylvania, I got to assume that Frank is going to be found in any scenario more than 51% at fault. Therefore, Dennis would be able to get a certain amount of damages. Frank is never getting any damages. To the extent that you even understand who a defendant is versus a plaintiff versus whatever it is, which during their persecution of the case.
Yeah. And at no point is D going to be on the hook, which is how this all somehow winds up right before their roll credits.
Of course, that's how it ends up, is that possibly one of the lawyers actually is found to be fully liable. The majority vote declares her to be at fault.
Bizarre show, but
kind of hilarious. Geoff, do you have a certificate indicating that you don't have donkey brains?
I don't. I have a number of certificates on my wall, but not one attesting or certifying that I am not donkey brained.
So can you explain how that means that you aren't donkey brained, even though you do not have a certificate showing otherwise?
Because you don't generally, just because you have a certificate saying you're not donkey brained doesn't mean you can't also be an idiot and an ass and all of that.
I would like to add into evidence Article 1. Mac, will you please read this document?
By the power of the Commonwealth of Pennsylvania, Reed Mental Institution hereby decrees Frank Reynolds to not have donkey brains.
What? That is an official document.
What is that?
Donkey brain on it?
It's written right here in plain English. Frank, would you like to clear this up for everybody?
All the kids in the neighborhood knew I got sent upstate. So they started calling me Frankie Donkey Brains. And it was very traumatic. So I got my mommy to drive me back up to the loony bin where they signed this official certificate exonerating me of all donkey brains.
Yeah, great. What does this have to do with anything? Oh, well, Dennis, if by your own admission, someone who has donkey brains could be considered reckless or moronic or idiotic, and my client Frank here has a state-issued certificate clearing him of having said donkey brains, then I ask you this. Do you have any such certificate? What? We don't want a donkey on the road eating cereal. We know Frank's not a donkey. How do we know you're not a donkey brain man?
Why would I have a certificate?
You don't have a certificate?
The burden of proof is not on me.
The defendant will answer the question.
The defendant? I'm not the defendant.
Just answer the question.
No. No further questions.
The idea that of turning Frank's possession of the certificate around on Dennis because Dennis doesn't have a certificate saying he is not a donkey brain is very comical, but also not in any way evidence of anything that would be admissible at trial. I don't know where to begin with that question. There's a question of evidence too. There's no attempt to authenticate this document. It appears to be the seal on it was wrinkled, and immediately I was suspicious of its provenance, though the story behind it is crazy enough to be true.
And I will also note, and one thing that may not come out of this show is that Frank, Danny DeVito's character, is a multimillionaire.
Really? Okay.
And basically, the whole premise of the show is basically him funding and enabling the other four's stupidity.
Craziness. Okay.
So anytime there's a whole thing, and this is the kind of funny part, where he's a multimillionaire who, let's be honest, could afford to hand a couple $100 over to Dennis for him to fix whatever he needs to fix.
Sure. And could afford a car that has newer technology than a tape deck that he is using as direct. Like,
that's awesome.
One of them has recorded directions on a cassette tape for him to get to the bar?
I think to get anywhere.
But apparently not a car with Bluetooth and a cell phone with GPS is odd.
And let's also say, this was from 2012. It's not like it was from the 90s.
Right, we're not talking about a 90s sitcom or anything.
No, this was like late 2012. No, the tape deck with the...
It had been on for 8 years in 2012? Man, this show has been on for a long time. Okay.
Yeah, believe it or not. 17 seasons of Always Sunny in Philadelphia.
Okay.
If that makes any sense to you.
Mac, why don't you believe that? Huh? I'm just wondering, why don't you believe that you could pass down a gene that would eventually evolve into a race of supermen? Why?
Oh, that's a silly question. Because evolution doesn't exist, of course.
I'm sorry?
Oh, could you repeat that again for the room?
Because evolution is bullshit. It's not real.
God damn it, recess!
Is this just a dumber version of the Scopes monkey trial? I don't know if that's what they were going for, or if it would be a very deep cut. It's a very deep cut if that's what they were going for. But I also think it's apropos in the sense that trial. So for those of you who do not know what the hell I'm talking about, the case was the state of Tennessee versus
Scopes.
John Scopes. I was looking up the first name.
Oh.
John Scopes from 1925. And the very short version, I don't want to over talk about this because we are totally getting into the weeds on this, but it's kind of hilarious. There was a act on the books in Tennessee called the Butler Act, which was a state law that outlawed the teaching of human evolution in public schools, something that Geoff would have been all over if this was 2026.
Definitely. Yeah.
You may even know this more than me, Geoff. As I understand it, it was almost like the trial was staged. Like the ACLU knew that they were going to be going after him. And there was I'm not going to say they worked together, but in some ways they didn't. They didn't go against each other to make the trial happen.
I believe so.
But like both sides, so the one side being the ACLU and the other side being the state of Tennessee, ended up having a trial over whether originally it was supposed to be like whether the law was actually constitutional and valid. It didn't really end up that way. It ended up being a complete nonsensical trial because the judge was this Christian fundamentalist who started every single day of trial off with a prayer and hated the defense from day one.
Now, that's something that still happens, by the way, but continue.
Fair enough. But also, the Scopes trial is interesting because two very well-known lawyers argued it. So you had William Jennings Bryan, three-time presidential candidate, former Secretary of State, was on the prosecution side, and Clarence Darrow was the principal defense attorney, along with the sort of main lawyer for the ACLU.
We're probably, if anyone's interested, this case became a play, and then a movie called Inherit the Wind that we will almost certainly be discussing on the podcast. So we'll go into even more detail about this, but continue.
Yeah. And now I will say, if you want to do a deep dive on this, you can dive on this you could dive into the transcripts. They've got everything.
Oh yeah.
Because it is, the more you dive into it, the more nonsense it is. But ended up becoming almost a philosophical debate on whether evolution is actually the thing you should be like, if it isn't a thing, right? And I think it led to one of my favorite random notes about this trial was one of the lawyers calling the other lawyer to the stand, which ended up I understand it got expunged at some point, but the fact that happened is hilarious.
Yeah, because William Jennings Bryan was a religious leader as well as former Secretary of State and all of that. And yeah.
And so Darrow calls Bryan to the stand and basically questions him on the Bible, is my understanding.
At least to some extent. I don't remember. It's been a long time since I've done a deep dive into the Scopes Monkey trial. I know Inherit the Wind is basically all about that exchange.
Yep.
But I think it kind of embellishes and expands that sort of cross-examination, we'll call it. But yes, there is a germ of truth in that exchange happened.
And as I recall, and again, I'm going to have to go back and double check all this, didn't the judge basically tell the jury that he was liable? Effectively. And Scopes was found, I think he was ultimately sentenced to pay a fine of $100 or something. Right. Which then got overturned because under state law, any fine over $50, that was up to the judge, not the jury. And so they overturned it. And then to go back to the fact that a weird decision, in the decision to overturn it, one of the judges essentially said, we would highly encourage the AG to not retry this case and let's move on. And that's basically what happened.
Yeah.
I really feel like there's an homage to that here. And maybe it's not done on purpose, but I think it's there.
Oh, I think it definitely is. And also bearing in mind that in 2012, that was in the wake of the Kitzmiller v. Dover case, which was basically a retread of the Scopes Monkey trial. And I'm probably going to get the year wrong, but I want to say it was like 2007 that all went down, where Dover School District in Pennsylvania was teaching intelligent design instead of, they weren't teaching like creationism, but they were teaching intelligent design and were sued rightly. And so that may have also been fresh in the minds of the writers at the time.
Fair enough. I will also say, and this is interesting, when I was watching, this did pop into my head, the fact that technically any two people who have a dispute can agree to have someone that's not a judge make a decision and decide whether or not who is liable. So there was that sort of weird part of my back of my brain that's they could have agreed to have Mac make a decision here and effectively operate as an arbitrator or mediator in this case.
Sure. Anybody can engage in alternative dispute resolution.
And so there was a part of me that was like, let's see where this goes. Because are we going to get to the end and be like, listen, if the two of them had some type of agreement that Mac is the judge and this is how the decision is, then I could. And in fairness, at one point they were like, they say like a majority rule thing. Then it gets weird.
And does Dennis ever agree to this, or he's just forced into this weird fake trial? I don't recall him ever being like, okay, let's do it this way.
So he goes along with it because I think he's like the sort of one source of some type of reason between the five of them.
Okay.
And I think I'm just going to explain to them what happened and we're all going to agree. But like somehow after 3 hours, they just decide to do it. They're in a mock trial-esque situation and no one agrees for Mac to be judge, but he is. No one agrees for him to be bailiff, but he is. He's also a witness. He's also technically an expert. He's also the jury foreman, if that's a thing. And
you say he's a witness. He's not in any way he witnessed nothing. He has no factual information about the accident. It's unclear to me what he was even supposed to be, air quotes, testifying about.
He was an expert witness on evolution, Geoff. How did you not get that?
Why was that? Yeah, let's take that as given for the moment.
How did you not get that? And how is that not relevant to the question of whether someone is negligent for a car accident?
But it was like his credibility was in question.
Correct.
And that's what led to the whole evolution discussion. But why was his credibility ever an issue? That's the part that as I think back, I don't even,
Geoff,
I know it's this show, but I don't understand. The rest I could follow along, but then suddenly he's just I don't know. I was very confused.
Oh, when you put it like that, you got me. You know, I'm on Dennis's side now. He just convinced me.
Hold on one second, though, Charlie. It occurs to me that Frank assumed responsibility for a potential spill the second he took the wine.
He's right. I knew the risk.
So in this circumstance, it would appear that Frank is at fault. And therefore, in the car, Dennis is at fault. I am on Frank's side, case closed.
I pushed you! Boom, you nailed it. You know what? Mac just made the most credible argument of all.
Hold on a second. Hold on, Charlie. Credibility? You're interested in credibility? I would like to call my next witness, Mac. So, Mac, you seem to be pretty locked into Frank's side at this point, right? And your opinion, it carries a lot of weight around here, doesn't it?
Oh, absolutely. I'm a tastemaker around here. Pretty much what I say goes. And I've decided that Frank is the winner.
Yeah. And Charlie, you find Mac's arguments to be fairly credible and convincing?
I do. Yeah, he makes a lot of good points. He's a good judge, and he's an even better bailiff.
So if you find Mac's arguments to be so credible, why is it that you disagree on the subject of superhumans?
Well, we don't.
What? What does this have to do with the case?
Mac, if your character isn't credible, then are your arguments?
Strike this line of questioning from the record, please.
Overrule. Let her continue.
Mac, do you or do you not believe that you could create a superhuman race of strong men through genetic mutation and evolution?
What difference does that make?
Geoff, he is the tastemaker. How can you not? He's by his own words, he's the tastemaker.
Okay. All right. Fair enough.
I understand why you're confused by this.
It's probably on me. I was not doing a close enough read of the text of Always Sunny here.
Let's briefly talk about the fact, let's say, hypothetically, that he did have something to add. I don't know. He's an accident reconstructionist or something that would actually be helpful to the case. You don't just throw someone up there and say, well, you're an expert in this. Discuss. Geoff, would you like to talk about how an expert actually comes into a case in normal life?
Sure. It's a long process in real life. Generally, so let's talk first about why we have experts. Because generally, in order to be a witness and give testimony at trial, you have to have essentially firsthand knowledge about the events that are at the crux of whatever is being disputed. A fact witness like that cannot give their opinion on stuff. They are there to testify as to what they saw, what they heard, their firsthand experience of the facts. There are situations where the things that have to be discussed are, I believe the phrase is, beyond the kin of an average person. In essence, you could present the facts of a medical issue, and the jury would not have the requisite knowledge to understand what those facts meant. And so you have to have experts who are qualified through a process in the court where you demonstrate that basically go through their CV and try and demonstrate that they are indeed an expert in whatever they're going to opine on. And they present testimony as to what these facts mean when all put together so that the jury can understand what's going on. And each side has their own expert witnesses that will have different opinions, and the jury has to decide which one's right. It's absurd when you really dig down into the whole expert thing. But each side has had, once you get to trial, their experts waiting in the wings for a while. They'll have had an independent doctor look at the plaintiff and assess their medical condition and write up a report, and that becomes part of discovery, which happens well before trial. The defense will have their own doctor examine the plaintiff or go through the plaintiff's medical records, what have you, and produce a competing report, and then it becomes a duel of the experts, and it all gets rather expensive too. And yeah, then they go through a sort of voir dire process.
Ooh, fun. But the ones in my case, typically I hired an economic consultant and PhD and whatever to opine on damages. They're an expert. You can sit there and poke holes in their analysis, but you can't really poke holes in the fact that by themselves, they are going to give more information than the typical normal non-expert. I think, as you said, generally speaking, an expert's going to provide some type of report that's going to sort of state all of their conclusions. Not always, though. There are some jurisdictions where you don't have to give a report, especially at lower level state courts. You basically just have to tell the other side, this is my expert, and this is generally what they're testifying to. If they want to depose them and find out more information, they're allowed to do that, but you don't necessarily have to give a report or everything on every single case.
Sure. So our expert here is...
Yeah, so I was about to say, so the expert here, who is, of course, Mac, on evolution...
For some...
You're saying that typically you can't just call them to the stand and be like, hey, talk about this? Oh, especially after spending 3 hours creating demonstratives.
Weird exhibit.
Two different sets of 3 hours. First to do the trial meter, which, by the way, I would like to have that in a courtroom where it's just as the trial's going on, jurors moving it. What that made me think of, the whole trial meter, was basically in the show Bull, which we're going to hit at some point, the star, Dr. Bull, is basically a psychologist who runs a trial analysis corporation. And they basically match up every single juror in an actual trial with a fake juror that they are doing their testing on. And they are identifying which way they're going to go based on their blah, 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 blah.
Is he a poker player as well? Does that factor in at all?
He may be. I'm sure he flops a straight flush, and they claim he's the smart. He reads everybody so well, Geoff, just like I complained about it.
If you don't know what we're talking about, go back and listen to our Lincoln Lawyer episodes.
Or my sidebar from not that long ago.
Yeah, that's true.
This made me think of that show because basically they're in real time looking to see how the jurors are reacting. And when something bad happens, they all turn to red. And when it's good happens, they all turn to green.
Okay. It's a focus group trial.
Essentially.
Okay.
Correct. And that's what made me think of is we're having live time feedback. It would be like, I have an arbitration coming up in a month and a half. I think it'd be great if the arbitrator is just sitting there moving as the case goes along so we can see what direction they're going in. That would make it be more fun for us.
And I guess both the parties and the attorneys are also on the board and moving.
Although it would be really sad if one of the lawyers jumps to the other side, as is the case here.
That would not be zealous advocacy, let's say.
No, here's what's actually interesting about that. Don't get me wrong. There are times in a case where the other side makes an argument and you're like, shit, that's a really good argument. Or like, there's a legal argument or a legal loophole where you're like, oh, that's not bad. I don't think it's ever made me jump to the other side.
Sure. And to be clear, there are plenty of times where you take on a case and you're very clear with the client, look, we're going to lose this case. If you really want to take this to trial, we can, but I want you to know going in, this is not going to end well, no matter what I do. that happens.
And I'll say, when I started at my own firm, I always wanted to be as open and honest with the clients as possible because, Lord knows, there are some lawyers out there that will take any case that comes in as long as the client pays. And
Sure.
while that is a perfectly fine way to run a law firm, I feel like it's a little more stressful when you know you're always up against, especially when, I'm not saying you lie to the client, but you don't actively tell the client the concerns you have about the case.
Sure.
And in fact, I've lost a couple cases. Sorry. I've lost the client when I said to them, here are my 7 issues with this case. I am very happy to take it on. I will zealously advocate on your behalf. But just, I don't think you have a great chance of winning.
Yeah.
And there were a couple times where they didn't think that I was as committed. And okay, go to someone else who's probably going to charge you more and still lose. But It is what it is. So yeah, there's certainly times where you are aware as the case is going on that you may not be necessarily on the good side, but unlike Charlie and or D, I don't tend to show my hand and be like, yeah, I believe the other side now.
Sure.
Although I would like the trial mirror to be a real thing in life. That's the one thing I want to take out of the show.
Yeah.
What else can we talk about, Geoff?
So one thing that I wanted to note, and I guess we have touched on it already, is at no point do we understand what the damages are. Like, generally in a case like this, the first thing you have to establish is that a harm was done. And all we know is he spilled cereal. And if it was a cleaning bill, then that is a harm. That is an expense. That is legally cognizable. But we don't know. We don't know what he's actually seeking to recover here, which is basically the key facts of the case.
The true opening statement would be, Frank rear-ended me. I was sitting at the red light, not moving. He rear-ended me. That caused me to spill my food, which cost me this much money to clean.
Yeah.
Period. End of opening statement. And we can play the opening statement that actually happened on Frank's side. Still not sure why Frank went first, but that's fine. No big deal.
Sure.
Moving on.
Okay. I'd like to begin with my opening statement, if I could. First off, who is the defendant in this matter?
That's not a statement.
All right. Irregardless, I would like to know, as Frank's lawyer, who I am persecuting or who I'm defending.
Yeah, prosecuting.
Okay, let me just nip this whole thing in the bud right now. Stop treating this like it's a trial and this is a courtroom.
Yeah, but the tables.
Yeah, but I was against that too, okay? Let's just present the facts to each other and then let's decide as a majority who's in the right. That being said, Frank would be the defendant.
I'm not the defendant. No, that implies that I am guilty.
He's right. If anyone's ever accused of anything, I automatically assume they're guilty.
You do, right?
I do.
Yeah, you do. I'm going to make you the defendant.
Okay, and I'll make Frank the defendant and then we'll split it up that way.
And in fact, as I recall, the opening statement was basically, who is the plaintiff and who am I persecuting? Which is a good start to the mock trial. Would be good to know.
Yeah.
How much is at issue?
Yeah. And I will say, we said at the beginning, Frank loses, except if Dennis never presents any evidence of damages, in which case Frank wins.
Or if he proves that there was any form of damage, he might win, but then he gets no actual damages. Like he wins on liability, but gets $0 effectively, or a token dollar or whatever it is. Yeah, fair enough. Trying to think if there's anything else. Oh, the burden of proof thing.
Oh yeah, that goes back. That kind of goes back to the donkey brain.
It does go back to the donkey brains, but I do remember Dennis saying, and I'm sure we'll drop in the clip, that I don't have the burden of proof here.
Do you have any such certificate?
What? We don't want a donkey on the road eating cereal. We know Frank's not a donkey. How do we know you're not a donkey brain man?
Why would I have a certificate? No, the burden of proof is not on me.
The defendant will answer the question.
The defendant? I'm not the defendant.
Just answer the question.
You technically do, to prove, because if you are bringing the claim and asking for damages, you do have the burden of proof, but the burden of proof is just more evidence than the other guy. So this is actually a confusion of non-lawyers out there. In a civil trial, the burden of proof is on the person bringing the claim. So if you are bringing claim, so here, Dennis is bringing the claim that Frank caused damage to his car. He needs to prove by a preponderance of the evidence that it is more likely than not that damage was done and that Frank is at fault. You do not have to prove beyond a reasonable doubt, which is what some people think is the general burden of proof out there. That is only for a criminal trial. That is the only time you have to prove beyond a reasonable doubt is in a criminal trial. And we can all agree that beyond a reasonable doubt is a very high bar. And we have talked about this many times on this podcast. Anytime you are a defense lawyer, you want to remind the jury as much as humanly possible that if there is any doubt in your mind that the crime was not committed by the defendant, you cannot find them guilty. That's not the case here. We have a civil trial here. Civil trial is a much different burden. And the only times that the burden changes is when it comes to fraud and a few other sort of higher level things where there might be a slightly higher level required. Clear and convincing evidence, which is certainly something higher than preponderance of the evidence, but less than beyond a reasonable doubt. We have talked about probable cause before, which is an even lower burden, but typically probable cause is just to get the subpoena or to do the initial search and seizure, whatever it is. That is a very low bar.
Going back to our Zootopia episode a couple weeks ago, it is an articulable suspicion is the basis for probable cause. And I'll note that even in the criminal setting, the beyond a reasonable doubt applies to guilt or innocence. At sentencing, in federal court, when judges are applying all these, there's all sorts of federal guidelines as to what your actual prison sentence is if you're convicted of a federal crime. Those factors often don't have to be proved beyond a reasonable doubt.
Yeah, the burden of proof is mostly when it comes to liability itself. Whether you are guilty or not guilty, whether you are responsible or not. Yeah.
And I will say this is made slightly more complicated in that Dennis is bringing the claim. Yes, he was struck by Frank's car. That is his claim. Frank is essentially arguing as a defense, as an affirmative defense, that Dennis contributed to the damage, or really that Dennis was entirely responsible for the damage, which is something that Frank, he's not making a counterclaim, but in an affirmative defense, the person raising the affirmative defense then has the burden of proof when you're not in a criminal setting. Because in a criminal setting, if you raise self-defense, as far as I can remember, the burden pretty much still remains on the prosecution. I feel like I might be speaking out of turn there. The defendant has some responsibility to show that the defense is legitimate. And once you've demonstrated that minimum basis, then the prosecution's responsibility is to show that it was not self-defense.
And again, I think that's different in the criminal and civil context. In civil, whoever brings the affirmative defense, they have the burden of proof. But again, the burden of proof is just preponderance, right?
Yeah.
I believe in a criminal case, it's a little different. Good example of an affirmative defense in the civil case is proving whether the time limit to bring the claim has expired. Like, plaintiff brings a claim, something happened, say, 5 years ago, and it's a contract claim. There was a contract, someone breached it, and the person who was damaged brings a cause of action for breach of contract. At least in most jurisdictions, or at least jurisdictions I practice in, some of them say it's a 3-year statute of limitation, which means that you need to bring the claim within 3 years of the breach occurring. Let's say you don't realize there was a breach. You thought that they were doing everything correctly, and then you find out years later, actually, they didn't do the thing they said that they were supposed to do.
Sure.
That may allow you to bring the claim later. However, the person you're suing may bring that up and say, they should have sued 2 years ago. They've waited too long. That is an example of affirmative defense where you're not even necessarily saying that I'm defending the breach. You're saying, can't even bring this claim because it's been too long.
This comes up a lot in products liability cases where, you know, are you counting that time period from when you bought the product, when the product was built, or when it failed on you?
And then there's each jurisdiction that just has different rules on like, how long can you wait after that? Should you have discovered the defect? When did you discover the defect? Blah, 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 blah. But here there's basically two competing things. There is the actual cause, which is brought by Dennis, and the affirmative defense brought by Frank.
This is all parentheses after every
In addition to the mental incapacity argument that I still don't fully understand. If you're donkey brains, you would probably be eating cereal in your car. I don't know how that changes anything other than the fact that we're just calling someone donkey brained.
It is an odd decision. Admittedly, Your Honor, is my client the brightest person? No. But the fact of the matter is he was stopped at a red light and was struck from behind by another vehicle.
I have no further information. Right. Off we go. Moving on. Too fun. All right. We've been talking for 55 minutes on a 22-minute episode.
Yeah.
Jeff.
Yes, Derek.
Thoughts?
Now we're getting into recommendations now. So on the law, no.
I'm shocked. I'm shocked, Jeff. I'm shocked.
As to entertainment value, I'm on the fence because it went quickly, but at the same time, I have no desire to ever watch more episodes of the show. I don't really get it. But I guess I enjoyed it for that 20 minutes on the train while I was watching it on my phone. Sure. Nothing in it angered me, which for us means...
On our podcast, that's the bar, whether it's entertaining or not, is did it actively anger me while I was watching it? Now, I also say the does it anger me also directly correlates to how long it is.
Sure.
If it is a very short one, generally shorter ones irritate me less because it's over quicker.
Yeah. And it helps that it's an absurd...
When I first watched it, I was like, what do we even talk about? And I'm like, okay, it's a back to basics episode. That's the only thing we can do, because if we do anything further than that, it's going to be absolutely insane. I'm with you. Obviously, it does not get the law right. It was entertaining to me. It actually made me want to go back and start watching the show from the beginning.
Okay.
Just because again, as I said, I've watched probably 20 episodes, no concept of where they are in the timeline of the show. I actually want to go back and start doing a watch and see if it's something I get into. So yeah, we'll go with that. That was fun.
It was.
Dumb, but fun.
Yeah.
And I just want to note, one of the reasons why I think this didn't annoy me was that it wasn't trying to get the stuff right.
Oh, sure.
Like How to Get Away with Murder, which I think is your quintessential, this angered me, almost seems like they're trying to show you what it's like, or what a good lawyer is like, or what like... And I know it's a little bit, they know it's a little extreme, but I don't think the creators truly realize how insane it actually is. Here, they know how insane it is.
Yes.
It's insanity. It's fun to watch because it's insane. They don't get anything right, but they know they weren't going to get anything right.
They weren't trying to.
It's not like Rob McElhenney is not going to listen to this and be like, guys, we were trying to get this exactly the way. No, we knew what they were doing. Which makes
nothing in this
fun.
show is trying to hold this out as an accurate representation of the legal system. Unlike Law and Order, or the next episode that we're going to do, All's Fair, or How to Get Away with Murder. That's going to be fun.
On our next episode, we will ask Mike if he has a certificate of donkey brains.
Yes. And he will not know why.
Ooh, that's what we're going to start All's Fair with. Excellent. Good times. All right. Thanks for listening, everybody. We'll be back. The Not So Grand Jury is sponsored by Morwa PLLC.
The opinions expressed in the Not So Grand Jury are those of the hosts themselves, and not of their respective employers.
The theme music for the Not So Grand Jury is from Gustav Holst's Jupiter and is in the public domain.
If you'd like to get in touch with us, if you want to suggest future movies, or even if you want to offer corrections, you can email us at notsograndjury@gmail.com or message us on any of our social media accounts.
The Not So Grand Jury is copyright 2026, all rights reserved.